English legal dictation 120 words per minute. Ready? Start. The management as well as the employee have impugned the judgment and order of the learned presiding officer School Tribunal Latur passed in appeal number 16 of 2009 dated 1/10/2009. Para. Respondent number 1 in writ petition number 7446 of 2009 will be referred to as the appellant and the petitioners will be referred to as the respondents as to their original status before the school tribunal. Para. The parties are not in dispute that the appellant was appointed by following due procedure of law. He was terminated on 13/4/2007. He had impugned that termination by appeal number 51 of 2007. When the appeal reached for hearing, the respondents withdrew the termination order 13/4/2007 and ultimately the appellant withdrew the appeal. Thereafter, on 18/12/2008, a show cause notice was issued to him framing 17 charges. Out of those 6 charges, the subject matter of the previous appeal was the same. The charges leveled against the appellant are summarized as follows. Para. The appellant had leveled the allegations against the respondents that in 2007, respondent number 1 and 2 demanded rupees 2 lakh towards his appointment. He had paid rupees 3 lakh at the time of his appointment. He refused to pay money again. Therefore, the respondents started harassing him and leveling false allegations. The respondents denied the allegations. However, the respondents have a case for the appellant was negligent in performing his duties and committed misconduct. Therefore, after due departmental inquiry, he was terminated. The committee was constituted strictly as per the Maharashtra Employees of Private Schools Regulation Act 1977. They also did not deny the termination and withdrawal of the earlier termination order. It was pleaded that the appellant used to leave the school without leave from the headmaster. He was absent from 4/1/2006 and 15/1/2006 without leave and intimation. The headmaster issued him notices. However, he did not improve his behavior. The appellant made a false representations before the authority and published the newspaper news item, making false allegations against the institution. The students had many complaints against him. The complaints of misbehavior with the female students were also received. Therefore, by following the due procedure of law, he was terminated. Para. The petitioner had impugned the termination order contending that the inquiry committee was not constituted strictly as per the Capital MEPS Act. A fair opportunity was not granted to him to contest the inquiry. The principle of natural justice has not been followed. He cannot be jeopardized for the same charges that were alleged earlier, and the termination order based upon those charges was withdrawn. He submits that one of the members of the inquiry committee, Mr. M.S. Karkare, cannot be a judge of its case as he was converned cum member of the inquiry committee. The order sheets dated 8/4/2009 of the inquiry committee were also changed. The proceedings of the inquiry committee were violative of Rule 37 of Maharashtra Employees of Private School Rules 1981. The whole proceeding was vitiated for violating the provisions of the Capital MEPS Act. Para. The learned tribunal had that the appellant's services were illegally terminated on the basis of the inquiry report. Against that finding, the management has preferred the writ petition, and against the negative finding of constituting the inquiry committee as per capital MEPS Act, the appellant has preferred another writ petition. The management has impugned the judgment and order mainly on the ground that the tribunal has no power to reduce the punishment or impose the punishment as per his own. Once the tribunal held that the inquiry was properly conducted, he cannot exercise the powers to reinstate the appellant. The school tribunal has no power to reappreciate the evidence laid before the inquiry committee and substitute his own conclusion unless the principle of natural justice have been violated. The court has no authority to go through the elaborate evidence. The principles of natural justice has not been violated. Therefore, there was no scope to interfere with the termination order. Para. The appellant has assaulted the impugned judgment and order mainly on the grounds that the learned tribunal has erred believing the inquiry report and its constitution. The tribunal did not consider that a fair opportunity was not granted to the appellant to cross-examine the witnesses, and the charges number 2, 17 and 19 were vague. The tribunal did not take appropriate judicial review of the impugned order. Para. The learned counsel for the respondents has vehemently argued that the tribunal has erroneously modified the punishment. Such an order is without jurisdiction. The tribunal has no power to recess or reappreciate the evidence to bolster his arguments. He relied on the number of the case laws. He prayed that the impugned order is prima facie illegal as regards modifying the punishment on the basis of reappreciation of evidence. He also referred to the findings of the court to justify his contention. Para. The learned counsel for the appellant submits that the tribunal has the power of the civil court. Therefore, the tribunal can reappreciate the evidence. It is the only authority to enter into the findings of the charges. The management was based. The assignment of the question papers may differ from person to person. Hence, there shall not be a straight jacket for valuing the answer sheets. The management at his whims cannot say that the assessment of the question papers done by the appellant amounted to negligence of services. The tribunal has plainly referred to the evidence laid before the tribunal, and the material has not been reappreciated before the inquiry committee. Para. He also submitted his notes of written arguments. In the notes of written arguments, the facts have been reiterated and the questions raised before the tribunal have also been requested. It has been contended in the notes of written arguments that since the principle of natural justice have not been followed, the opportunity of cross-examining the witnesses is not guaranteed. Non-supply of the documents, statement of witnesses in spite of written complaint, or violation of principle of natural justice. There were two reports of the inquiry committee. However, both were violating Rule 37 of the Rules 1981. The charges leveled against the appellant were vague and not proved. His notes of written arguments seem that he has emphasized only on the legality of the constitution of the committee and violated the principles of natural justice. He also relied on a bunch of documents. Para. In reply, learned senior counsel for the respondents submitted that the fact remains that some witnesses were not examined. The committee report was by a majority of 2-1. The term principle of natural justice is wider. The request to cross-examine the witnesses was done deliberately late. That does not mean that the principle of natural justice has not been followed. Even he did not ask for cross-examination. Hence, it was presumed that he declined to cross-examine the witnesses. The objections raised in the writ petition were without foundation. In case if one of the committee members refuses to sign the report, it cannot be said that it was not a combined award in the absence of a nomination by the employee as per Rule 36 in bracket 4 of Rules 1981. The committee of 2 members is not bad in law. Again, he referred to various case laws and prayed that the petition be dismissed. Para. After hearing the respective counsels, the following points arise for determination. Para. Was the inquiry committee constituted as provided under Rule 36 of the Rules 1981? Para. Should there be a combined award signed by all committee members, else bad in law? Para. Can the tribunal reappreciate the evidence and substitute his own opinion? Para. Has the tribunal power to reduce or change the nature of punishment imposed by the employer? Para. The appellant has no complaint about complying with the formalities of serving the charge sheet, statement of imputation, and other statutory and mandatory procedures as required under Rules 1981 for initiating departmental inquiry. However, he has raised the objection that the committee constituted under Rule 37 was not constituted as per the mandate of the law. Para. He has objections that one of the members, Mr. D. H. Bhosle of the inquiry committee, was not the national awardee. He was over 75 years. Another member, Sri Karkare, cannot act as a member of the committee as well as the convener. Therefore, the inquiry he conducted is illegal. To bolster his arguments, he relied on the case of Vidya Vikas Mandal and another versus Education Officer and another 2007 AIR capital SC 395. In this case, the inquiry committee was not constituted as per Rule 37 in bracket 6 of the Rules 1981. This court had directed the management to constitute the committee in accordance with the rules and to go in the matter afresh. If the committee constituted under Rule 36 is defective, the tribunal has to remit the matter to the management with a direction to hold the inquiry afresh from the stage where the defect has been committed. In the case at hand, it is evident that Mr. Bhosle was a national awardee. The entire proceeding was gone as per rules. It is the further argument of the learned counsel for the appellant that Mr. D. H. Bhosle was above 75 years old, hence not competent to be appointment as a member. However, the learned tribunal has correctly absorbed by relying on the judgment of Sudha Bhaskarrao Shashikhede versus Yashodabai Shikshan Sanstha and others 2003 MHLJ 659 that the rule does not disqualify an awardee teacher if he is above 65 years of age. There is no age restrictions of appointing a member of the school committee. Therefore, there is no substance in the arguments that the constitution of the committee is bad only for the reason that Mr. Bhosle, the member of the committee, was above 75 years old and such persons are not eligible to be appointed as a committee member. Para. The further objection is that another member was the convener cum member and it is prohibited under the rules. Sub rule in bracket 5 of Rule 37 of Rules 1981 provides for nomination of the convener. It has been provided therein that the convener of the inquiry committee is the nominee of the president and he shall maintain all relevant record of the inquiry. The role of the convener is to maintain all the relevant record of the inquiry. Therefore, there may not be illegality in appointing the member of the committee as a convener. Para. Considering the material available on record and Rule 37 of the Rules 1981, there is no substance in the objection that the inquiry committee was not constituted strictly as per the mandate of Rule 37 of Rules 1981. Para. It is the vehement arguments of the learned counsel for the appellant that the third member of the committee did not put his signature on the report of the two members. It is not a combined report. Therefore, the inquiry report is bad. Tara. It is admitted fact that two members have recorded the finding against the appellant and one in his favor. It is admitted fact that two members have recorded the finding against the appellant and one is in his favor. The inquiry report was by the majority of 2-1. The member nominated by the appellant has submitted his independent dissenting report. Para. Learned counsel for the respondent submits that every member of the managing committee had a right to prepare their independent report and the rule of majority would prevail. Para. Sub-rule 6 of Rule 37 provides for recording the findings on the charges against the employee and its decision on the basis of these findings. The inquiry committee has also to suggest a specific action to be taken against the employee. It is the duty of the inquiry committee to forward the copy of the findings and the proposed specific action to the employee, head, education officer or deputy collector by registered post acknowledgement. The management has no scope to take an independent decision other than the action specifically proposed by the inquiry committee. The management is bound to implement the decision of the inquiry committee. Rule 37 is silent about submitting a joint report. Every member of the inquiry committee has independent rights to record the findings and conclusion and differ from the conclusions of other members. Therefore, it cannot be accepted that the report decision of the management committee shall be combined. There appears no violation of the rules. Hence, the objection of the appellant that the want of the combined decision of the inquiry committee, the inquiry visits has no force.
In the case of Sri Brijlal in bracket Supra, the issue was whether the tribunal could be termed as a civil court which possess power under order Roman 13, which possess power under order Roman 27 Rule 4 of the Code to record the oral evidence of witnesses. The court held that the school tribunal exercising jurisdiction under Section 9 of the MEPS Act possesses all the powers that are conferred by the Code on the courts of original jurisdiction, and the tribunal can be termed as a civil court which possesses power under order Roman 27 Rule 4 of the code to record the oral evidence of witnesses, even if the provision is titled as a right of appeal to tribunal to employees of a private school.